So I think there's a lot of conversation about the privileges. The information shared with in-house counsel is not privileged information. I think there was, something that happened. Supreme Court also. I think there was a ruling that came around that. What are your thoughts on that? This is one very critical element between like a lawyer or advocate and general counsel. So how do you deal with it?
See, I think this is very, very aligned to what we have just deliberated. We are no different than an advocate. There is no differentiation at all, in my view, except for whatever we think are the bottlenecks. So, if a privilege is available, which should be available because somebody, a business, is reaching it out to its counsel, and we are the general counsel, we are the lawyers to the business. The simple question is why that conversation should not be privileged. That legal privilege should be available to a general counsel as well. And there are enough precedents internationally, and various countries they recognize the legal privilege of a GC. So that is what I think.
Well, Aman, the way in which I look at is that, and this anomaly is also linked with the legislative framework of Advocates Act. Okay, it's linked with that. One is your professional body, Advocates Act or the Bar Council regulations, they don't acknowledge you as legal practitioner. And the follow-up of that is, which you will find in the Indian Evidence Act or the Bharatiya Sakshya Adhiniyam, now what we have. Now, what happened is, while the law doesn't say so, and let me tell you, law doesn't say so, even the earlier Indian Evidence Act or today's Bharatiya Sakshya Sanhita, there are two special sections under this law. This section 132 and there's another section 134. Section 132 protects client. The 132 mentions the word advocate. So for example, Akhil is an advocate, I am a client. If I am sharing my information with Akhil as an advocate, again mind it, as an advocate, then that advocate cannot share my information with anybody else unless I authorize as a client. Okay. So essentially 132 protects a client from advocate. That advocate cannot share that information. There is another section 134 which says that a legal advisor, which uses the word legal advisor, not advocate, and that says that the information shared with the legal advisor is protected. So it's a privileged information. So essentially it is protecting that legal advisor. Legal advisor cannot be made a witness or cannot be asked to depose evidence or cannot be asked to provide information, etc., which is the privileged communication between that legal advisor and the client. Now just think about this anomaly, that essentially it means, and particularly in the context of the organizations which are operating in different parts of the world or the multinationals. In one jurisdiction, say in United States, information shared by that client with the advocate, with the legal advisor there in US,
Right.
that is the privileged one. So the client knows that this legal advisor would not be using my information, obviously, or the legal advisor cannot be asked to depose evidence, correct? So it's protected, it's privileged. While at the same time, since the information shared by my client with the in-house counsel is not privileged information, so I can be summoned to provide that information. I can be summoned to disclose evidence. Now, the moment it happens, and if I am not protected, just think about the destiny of the general counsel. Which client would be sharing that information, a legal which is otherwise the legal privilege information, whether it's in-house counsel or general counsel?
Which essentially means that the company is going to share it directly with the
With the
counsel.
external
outsider,
counsel? Yes.
and with no role of general counsel
Absolutely.
within
So
it.
in a way, and it would lead to what? Just think about it. It would lead to then you are asking the company or the client, you better share the information with your external lawyers, not internal lawyers. Okay, because internal lawyers, that communication is not privileged. It essentially means that even at the time of preparation of case, where the number of months are gone in, all that would be an expensive proposition for the client. He will have to be then dependent on the external lawyer. And all said and done, with all due respect, the strategy on litigation, strategy on contracting can only be built internally. While the same person who can otherwise provide you support, he is not in a position to provide, because then the client doesn't trust him. So this is the anomaly, and I think somewhere, and a good that you asked this question, somewhere these discussions should take place. In fact, the last year's decision, in fact, where we intervened, where we are already, under review right now, that last year discussion, this judgment is wrong, is fundamentally wrong in my view, for not only because of the interplay of section 132 and 134, but also because that was based on a particular judgment which was delivered in some civil law jurisdiction, not in common law jurisdictions. There are ample amount of jurisdiction, case laws on the privilege information or the privileged rights in the common law jurisdiction. You don't follow those common law jurisdiction while we are the common law country in a way, correct? But then we relied on some civil law jurisdiction, that too, or I think because that case was pertaining to some competition law. Now, a civil law jurisdiction, a competition law case, you are maintaining or passing that judgment based on that law. I think that this would be unfair to the people at large or the general counsel community, in-house community, and not in the larger interest of corporates in India.
And even under the Companies Act. So we mentioned in our petition that even under the Companies Act, the law recognizes privilege to a legal advisor.
So have you included? So you've included, this part, the privileged information also in
The petition.
the representation that you are making to.
Not really, because that matter is sub judice right now. So not really on the privilege part, because to our understanding, Aman, law is clear. Law is not, there is no anomaly in the law. The anomaly is in the interpretation of law. Because and also mind this, 134 today, because the Bharatiya Sakshya Sanhita came only recently. In the earlier Indian Evidence Act, even that phrase which I am talking about, the legal advisor, there they used to have the multiple words, I think, advisors, or something, some vakil and all that, those kind of things. They are very conscious in terms of using only the word legal, the advisor, and the distinction of using the word advocate in 132 and using the word legal advisor in 134 is intentional, it's deliberate, just to protect both the entities.
So the new definition which is proposed by the Bar Council of the legal practitioner, it says advocate or a law graduate enrolled with the Bar Council. So it doesn't leave a room for a general counsel.
Yeah.
And that's what we are saying, expand the definition. It has to be expanded. You cannot ignore the work done by you cannot ignore the work which is delivered by law graduates. Let's not talk about general counsel, law graduates who are providing legal services.
Right.
So how can you not regulate legal services?
Are we not legal advisors?
Yeah.
Yeah. I mean, why a general counsel is hired by any company?
Yeah.
If exactly.
And you don't want to regulate that.
Yeah.
No, and you don't want to give that legal advisor the same privilege which the law provides. The Bharatiya Sakshya Adhiniyam provides that. But then still you say that no, you are not legal advisor. Why for? What for? Only because I am having a relationship with my client as a salaried employment. Can my drawing a salary or remuneration can be the criteria? Now, if that is the criteria, why all those government advocates, those solicitor generals or advocate general, attorney generals, or even those lawyers who are working in the government organizations, why that is privileged? Are they not filing litigation? Are they not withdrawing remuneration?
So does the color of money change if it is paid as a salary versus it is paid as a fees?
But in that case they are drawing salary.
That's what I'm saying. That's what I'm saying.
And they are as commercial, because most of the litigations today in the corporate world, they are largely also initiated by the government. And you are also drawing salary from the government, no?
Yeah. So I think that distinction is also gone.
The distinction is also flawed.
Yeah.
See, that is 1961.
Yeah.
Today is 2026.
Yeah.
Things have gone under the Ganga. So, flown, lot of water has flown. So
Yeah.
please recognize what has changed. Yeah.
Flawed. We
Yeah.
need to, and I believe, because all those people who matter, they have that knowledge. I am, frankly, Aman, I'm not too sure what bothers them. What is the problem? We are not taking away their work. They would continue to be legal, counsels in the courts and all that. We are not saying that we would be appearing in the courts.
I think you've explained it very nicely that you are the one within the organization who is strategizing the law, who is basically a bouncing board for the law firm also to execute that work and not the promoter or the CEO. Yet I think if somebody is getting threatened, then I mean
Then why the information? You are in fact questioning the very relevance of general counsel.
yeah, exactly.
Because then there is no need of general counsel. You better outsource everything to an external lawyer because your information is privileged there only. You don't need a general counsel.
So do you need only people who take work and give it to law firms?
Yeah, either you actually.
But then they are not supposed to read the documents.
Yeah, they're not. Exactly. That is also very interesting.
Because if you read the
There should
document,
be
you
a
will
list.
interpret the law.
There should be a closed envelope which is passed on from one
Yeah.
table to another.
So that used
Is
to be
that
the
how you wanted the role of a lawyer?
It's an unfortunate part. It bothers me. Look, Aman, somewhere we need to acknowledge, recognize the issue and start solving this. We are not doing it for our benefit. We have crossed all that, limits and age and etc. We are not doing it for ourselves. We are wanting it to be for the larger social goods, for the larger economic good.
So
But what is the argument? I
See
also
what
want-
we are requesting, simple request is, don't reject our representation without a consultation.
Yeah,
Please involve us in a consultation.
yeah.
Please give us an opportunity to explain ourselves.
But Akhil, what is the argument they are giving that why this information is not privileged?
See, we have no direct information what is the decision or the thinking is.
And
there.
has nobody ever raised any objections on this?
See,
so
who will
far?
raise this issue? It is only one GCAI body, because
Yeah.
that is the only body in India
Yeah,
who is doing this kind of work
right.
for the underprivileged.
Yeah.
Others are, doing conferences, events, whatever. So that's their business model, which is fine, which is appreciated. But this work is being done by us.
Yeah.
Therefore, we know it's everybody's pain. It is every general counsel in our council's pain, and that is why the first question: why did we create GCI?
Yeah, absolutely. Perfect, sir. Thank you so much for being here, and all the very best to General Counsel Association of India and all its initiatives in future. So that was Dr. Akhil Prasad and Sanjeev Gemawat with us on this very special podcast of LawWiser. Stay tuned, and we will be bringing in more insights from them in future on the developments that happen at GCAI. Thank you.
Thank you very much.